Good afternoon, everyone. I am John Miguel T. Esquivel, and this afternoon I will be discussing about the affidavit and information. Before I begin, let me discuss to you first my objective. At the end of this lesson, students should be able to understand what an affidavit and information are, why they are used, and the laws that support them, and appreciate the value of honesty and fairness when making legal documents. And lastly, practice writing a simple affidavit and information in the right format. So, let's have a background. What is this affidavit all about? So, what is affidavit came from? From the origin Latin word, affidare means he has sworn or to pledge one faith. And it is started in England during Middle Ages as part of their legal system. And later on, it is spread to countries influenced by English law like the Philippines, US, and etc. So, it uses a written statement of facts that a person swears is true. So, definition of this affidavit is that it is a written legal document where a person called an affiant formally declares facts and swears that these statements are true. It is made voluntarily and carries the same weight as giving testimony in a courtroom. Unlike a casual statement, an affidavit is sworn under oath, meaning the affiant understands that lying in the document can result in legal penalty such as perjury.
What is an affidavit? An affidavit essentially is written testimony. It is a witness's statement that is reduced into writing, and the person signs and swears that the testimony in that affidavit is true and accurate. Affidavits could be used at all different stages of a litigation, including during motion practice, where the parties try to eliminate certain questions of law in advance of trial.
And when a person makes an affidavit, it cannot be valid unless it is signed in front of an authorized officer. So this officer have important roles in affidavit. So first is the notary public, who is appointed by the government, ensures that the person signing is really who they claim to be and that they are signing voluntarily. The notary then places a seal or stamp to prove the affidavit is authentic. The second thing is a lawyer. A lawyer can also act as an authorized officer. Aside from witnessing the oath, lawyers may guide the affiant about the legal effects of what they are declaring. And lastly, they are other legally designated authorities such as judges, court clerks, or even consular officials abroad, who can also administer the oath and certify the affidavit. And according to the Cornell Law School Legal Information Institute, an affidavit is a sworn written statement made under oath before a notary or other authorized officer. It simply means an affidavit is like giving testimony in court, but instead of speaking, the person writes down their statement, swear it is true, and sign in the front of an official. An affidavit are widely used in legal, administrative, and even personal matters such as court proceedings, financial transaction, immigration application, and property transfers. Now let's discuss the legal basis of affidavits. The legal basis of affidavits in the Philippines are legally recognized and regulated by several laws. The most relevant basis is found in the Rules of Court and in Republic Act number 9105 or the Notarial Practice Act of 2004. Number 1, Rule 132, Section 20 of the Rules of Court. This rule provides that affidavits are considered as evidence in court only when the affiant, the one who executes the affidavit, affirms or testifies to the contents of affidavit. This means that while affidavits are valid legal documents, they generally need to be confirmed by the affiant in court during hearings or trial. Number 2, Republic Act number 9105, the Notarial Practice Act of 2004. This law strengthened the role of affidavits by requiring that they must be subscribed and sworn to before a notary public or other authorized official. Section 6 of RA 9105 provides that notarization converts a private document like an affidavit into a public document which enjoys full faith and credit in evidence. This ensures that affidavits are authentic, trustworthy, and enforceable in legal proceedings. And number 3, Revised Penal Code or RPC, Article 183, also known as perjury. Since affidavits are sworn statements, the law punishes lying under oath. Article 183 states any person who knowingly making untruthful statements under oath in cases in which the law requires the applicant to swear the truth shall be guilty of perjury. This highlights the seriousness of making affidavits. A false statement can result in criminal liability. So the penalty of this is arresto mayor, its maximum period to prison correctional in its minimum period, which means 4 months and 1 day to 2 years and 4 months imprisonment, plus a fine not exceeding 200,000 pesos depending on the court decision. Now, let's discuss the purpose of an affidavit. An affidavit is not just about piece of paper. It serves a vital purposes in the legal system and even in everyday transactions. Now, let's explore the key purposes of an affidavit. I'll share each one of examples so we can better understand how they work. Number 1, evidence in court. The purpose of this is that an affidavit can be submitted as a written evidence in court cases. It helps strengthen a party claims or defenses by presenting the facts sworn under oath. Why is it important? Because it reduces the need for a witness to always appear in court, especially during preliminary hearings. Like for example, a witness who saw an accident may write an affidavit describing what happened. So this affidavit becomes part of evidence presented to the judge. And according to the American Bar Association, affidavits admissible as evidence when properly executed, especially in civil and administrative cases. Number 2, replacement for oral testimony. Affidavits can act as a substitute for live testimony when a witness cannot appear in person. So it is important because it saves time and resources for the court and protect witnesses who may be unavailable due to distance, health, or safety reasons. Like for example, a doctor who cannot personally attend a trial may submit an affidavit confirming the medical condition of a patient. And under the Rule 132 of Rules of Court in the Philippines, affidavits can be used in the place of oral testimony in specific cases. Number 3, proof of facts in daily life. So outside the courtroom, affidavits are widely used to prove facts or confirm statements in daily legal and personal matters. It is important because they provide a formal sworn statement that institution can trust as authentic. So I give you an example. Affidavit of loss. It is used when important documents like ID, licenses, or titles are lost. Another example, affidavit of support, used in immigration cases to prove financial support. And last example is affidavit of ownership. It is used in property or vehicle transaction. Many government offices, like for example, Philippine Statistic Authority, U.S. Citizenship, and Immigration Services require affidavit as part of their documentary requirements. So next, legal protection or perjury deterrent. Because an affidavit is made under oath, it carries legal consequences if the affiant lies. This ensures honesty and accountability, and it discourages false statement and uphold the integrity of legal processes. So, example, if a person lies in affidavit during a land dispute, they can be charged with perjury, which may lead to imprisonment or fines. So, what I have said earlier, the penalty of this is arrest to mayor, and its maximum period to prison correctional, and its minimum period, which means 4 months and 1 day to 2 years and 4 months imprisonment, plus a fine not exceeding 200,000 pesos depending on the court decision. And under the Revised Penal Code of the Philippines, Article 183, making false statements under oath is punishable as perjury.
Attorney Harold Respi Show! Bakit? Parang hindi natin masyadong pinagbibigyan ng kahalagahan yung notary public na yan at saka yung panunumpa na yan. Ang dami pa rin nagsisinungaling sa mga kaso na nagwi-witness. Ang dami pa rin nagsisinungaling sa kanilang affidavit. Bakit? Ang isang simpleng sagot dyan ay dahil hindi pinoprosecute. Ibig sabihin, dapat parusahan sa totoo lang. Sa isang perfectong mundo, may kaso yan, dapat kasuhan mo, dapat kasuhan. Pero sa totoong buhay dito sa practice, wala pa akong nakita, at least sa practice kung napakatagal na willing itong justice system natin, yung mga prosecutor na, alam ko nagsinungaling ka dyan, kakasuhan kita. Alam ko nagsinungaling ka sa witness stand, isa-cite kita for contempt, sabi ng judge. Or kaya kakasuhan, dapat i-recommend ko na kasuhan ka ng perjury dito sa prosecutor na to. So, hindi willing yung mga prosecutor na gawin yan. Hindi ko alam kung bakit. And yung jurisprudence din kasi medyo mahina. Parang walang masyadong jurisprudence na nagko-convict ng perjury at saka false testimony. So, hindi masyadong willing yung prosecutor na mag-prosecute. Hindi masyadong willing yung judges na mag-convict ng false testimony at saka perjury. Kaya nagkaroon ng culture na mahilig tayong magsinungaling sa ating mga affidavit and mahilig tayong magsinungaling sa ating mga testimony sa court.
And now let's discuss the types of affidavits. So first, affidavit of loss. It is when an important document or ID like a passport, diploma, or ATM is lost. So this affidavit is used to officially declare that you lost a valuable item or document if is often required before requesting a replacement or securing a new one. Like for example, if your passport get lost, the government will ask for this affidavit to process a new one.
Alright, yan. Si Makoy. Hi, attorney, paano po ba mag-apply ng affidavit of loss? Marami po bang requirements? Makoy, ang affidavit of loss, napakasimple lang gawin yan. No, wala ngang requirements yan. Ang kailangan mong gawin, pumunta sa isang notaryo publiko. Tapos, isalaysay mo lang kung paano nawala yung bagay na nawala. No, pwedeng English, pwedeng Tagalog. Tapos, ipanotaryo mo, affidavit of loss na yun. Yan. Maraming salamat po sa inyo. Ingat kayo at tulad ng lagi kong sinasabi, matulog ho kayo na mahimbing. Dahil ang natutulog ho na mahimbing, siya ho yung panalo. Yan. Maraming salamat po sa inyo at good night.
Next example is affidavit of support. When one person declares financial support for another, often for immigration or schooling, so this shows that one person is financially capable and willing to support another. It is commonly used in immigration cases, school admissions, or travel requirements to prove that the applicant will not be a financial burden.
AOS. Ano ibig sabihin ng AOS? Depende sa bansang pupuntahan mo. Like for example, sa Dubai, ang ibig sabihin niyan, AOSG or Affidavit of Support and Guarantee. Pag ikaw lalabas ka ng Pilipinas at merong magi-sponsor sa'yo, hindi mo gagastusan yung sarili mo, definitely, kinakailangan mo ng AOSG or AOS. Or else, upload ka pagka wala kang dala nun. Ganon kasimple yun.
So next is affidavit of desistance. It is when a complainant formally withdraws a case or chooses not to pursue charges. This is used when the complainant who filed a case decides to stop pursuing it. It tells the court or authorities that the complainant is no longer interested in continuing the case, often after a settlement or reconciliation.
Attorney, sinampahan ko ng estafa o panluloko ang kapitbahay ko, pero nagkaayos at nagkapatawaran na po kami. Pwede ko po bang i-atras yung kaso? Pwede kang gumawa ng affidavit of desistance o sinumpang salaysay para iurong ang kaso. Pero hindi basta madidismiss ang kaso, lalo na kung ito'y isang criminal case dahil hindi lang ikaw ang biktima sa criminal case. Biktima rin ng Estado, kaya people of the Philippines ang tumatayong kalaban ng akusado sa isang criminal case. Kailangan muna ng pahintulot ng hukom o piskal bago maiatras ang criminal case ng tuluyan. Kaya't bago maksyon, lagi muna pag-isipan. Ito si Attorney Tony Roman, handang magbigay ng free legal advice para sa inyong katanungan.
Next is joint affidavit. It is a sworn statement by two or more persons attesting to facts they both know. This affidavit is signed by at least two people who can confirm the same fact or event. Since it comes from multiple witnesses, it makes the statement stronger and more credible. An example is when two neighbors testify in writing about what they saw in an accident. And another example is affidavit of undertaking, a promise to do or not to do something often used in business or legal transaction. This type of affidavit serves as a written pledge. It is a way of assuring that a person will fulfill an obligation or avoid doing something. For instance, students may sign this affidavit promising to submit missing school requirements at a later date. The next example is affidavit of guardianship. It is declare legal guardianship over a minor or dependent. This type of affidavit is executed to prove that someone is the legal guardian of a child or dependent. It gives the guardian authority to make decisions and act on the dependent's behalf. For example, a relative may use this to take legal responsibility for child if the parents are unavailable. And another example is affidavit of complaint. It is used to file a criminal or civil complaint stating the facts of the grievance or grievance. So this affidavit serves as the formal start of a case, whether criminal or civil. It contains the complainant's detailed narration of the grievance, making it the basis for filing charges in court. Like for example, a person who is scammed may file the affidavit to bring the matter before authorities. Next example is general affidavit. A flexible affidavit used for miscellaneous declaration not covered by specific types. This is a general purpose affidavit that can be used when no specific type applies. It allows a person to declare facts formally under oath for any matter. Like for example, if someone may use a general affidavit to confirm their identity or personal status when required by an office or institution. Now, you might be wondering, where can we actually get an affidavit here in the Philippines? So, I will be discuss where we can apply an affidavit. Number 1, the notary public or law office or courthouse. Almost all affidavits must be notarized to be valid. You prepare a request, a draft of the affidavit, then bring it to the notary public. A licensed lawyer authorized to notarize the documents. Once notarized it, your affidavit becomes a public document with legal weight. Next is barangay hall for community level matters. like simple complaint, desistance, or guardianships, you may ask assistance from your barangay captain or secretary. They can witness and sometimes provide forms for certain affidavits. Next is municipal or city hall. Some city hall or municipal legal offices provide affidavit services, especially for affidavit of loss, guardianship, or undertaking. The civil registrar may also require certain affidavits, like for example, your birth certificate corrections. The next example is police stations. For affidavit of loss, your IDs, license, wallet, phone, etc., you usually report it to the police and execute an affidavit at the police station. The affidavit is attached to the police blotter report. And next is law offices or private lawyers. If the affidavit is complex, like for example, complaint, support, or guardianship, lawyers can draft the document properly before notarization. And last is embassies, consulates if abroad. If a Filipino abroad needs an affidavit for immigration, school, or guardianship, they can go to the Philippines embassy or consulate. Every affidavit follows a standard format, and it's made up of several basic parts. So let's go through them one by one, the basic parts of affidavit. So first is the title. This simply states what the affidavit is about. Like for example, affidavit of loss. Second is the introduction. This part gives the personal details of the person making the affidavit, also called the affiant. Third is the statement of facts. This is a clear and numbered narration of the facts stated truly or truthfully and in order. And the fourth one is the signature of the affiant. So the affiant signs the affidavit to show that they stand by what they have written. And fifth is the oath clause. This is a declaration that everything stated is true and correct, made under oath. So, notarial section or jurat, and finally, the notarial section, also known as the jurat. This part is signed and sealed the notary public, which makes the affidavit officials and legally binding. So in conclusion, an affidavit is simply written promise of truth. It may be about loss, support, or complaints, but all of them remind us that the honesty is very important in legal matters. Knowing its purpose and types help us understand how people use affidavits in real life, to protect themselves and others. So next topic I will be discussing is the concept of information in legal writings. In the field of law, information plays a crucial role because it serves as the foundation of legal documents, proceedings, and argument. It is through accurate, organized, and well-presented information that lawyers, judges, and legal practitioners are able to establish facts, interpret laws, and arrive at their fair decisions. Understanding how information is gathered, structured, and used in legal writings is important not only for legal professionals but also for anyone who wants to appreciate how justice is administered. In this report, we will explore the meaning, purpose, and significance of information in legal writings, as well as how it ensures clarity, precision, and credibility in the practice of law. So, when you say information from the origin word of Latin, informare, which means to shape, to form, or instruct, and developed in English common law courts by the 40th and 50th century. It was already used by prosecutor as a formal written accusation of a crime. So without needing a grand jury. So it is used a legal document filed by the prosecutor to change someone with a crime in a court. So in the definition of information, the Philippine law, an information is a written formal accusation of a crime written in a court by public prosecutor, or also known as a fiscal, against a person accused of committing an offense. Unlike an affidavit or complaint, an information is not simply a narration of facts, but an official charging document recognized by the court to begin a criminal trial.
If you've been charged in the criminal justice system, you may hear your lawyer talk about the information in your case. The information in your case is actually the formal charging document telling you what crime you are alleged to have committed. It's important to know what that document says because it gives you notice on what you are having to defend yourself. It also tells you whether you are charged with a felony or a misdemeanor. Screenshot and share this for more legal information.
So, why is it important in legal writings? In legal writings, information serves as the backbone of criminal cases. It more than just a words on paper. It represents the balance between the government duty to prosecute crimes and the accused's right to fair trial. So, without clear and precise legal writings in the information, the case may be dismissed or being vague or defective. So now, I will be discuss the legal basis in the Philippines. So in the Philippines, we also have legal bases that guide how information is used in legal writings. I'll give you clear examples is found in our rules of court. So under the rule of 110 section 4 of rules of court of the Philippines, information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Another example is Republic Act number 5180, also known as the Prosecution Service Act, and later laws also strengthened the authority of public prosecutor to file information. And the legal basis is the Constitution. Article 3 Bill of Rights ensure due process and the right to be informed of the nature of cause of accusation. And next example is Revised Penal Code and Special Penal Laws. Provide the crimes that can be charged through an information. So this shows how important it is to present information clearly and precisely because it protects the rights of the accused and ensure the due process. And overall, our laws and rules remind us that legal writing should always be accurate and truthful in order to uphold justice. Now, let us look the characteristic of information in legal writings. So number 1 is filed by prosecutor. Only public prosecutor from the office of the city or provincial prosecutor or office of the ombudsman for special cases can file an information. Another example is written and formal. It is not oral, it must be in writing, follow the prescribed legal. And another example is direct accusation. So it's directly charges a specific person with a crime. Another thing is filed in court. It becomes the official basis for the court to acquire jurisdiction over the accused in criminal cases. So another thing is does not need a grand jury. Unlike the US, where a grand jury indictment may be required. So the Philippines only requires a prosecutor's determination of probable cause. And the difference between complaint and an information, a complaint can be filed by any person who has knowledge of a crime, often the victim. And when you say an information, is always filed by the prosecutor after reviewing the evidence and find the probable cause. Purpose of filing an information. In the Philippine justice system, an information is a written formal accusation filed by a public prosecutor in court charging a person with a specific crime. It serves as the legal foundation of a criminal case, ensuring that due process is observed. So, what is the purposes of an information in legal writings? So, number one is initiate a criminal case. So, it is officially start the prosecution. An information is the formal written accusation filed by the prosecutor in court. Once submitted, it signaled that the government is officially bringing the case against the accused. Without this document, the court cannot proceed because there is no formal case to hear. In the Philippines justice system, the filing of an information is the starting point of a criminal trial. And according to the Rule 110, Section 4 of the Rules of Court, states that the criminal case is prosecuted by filing an information in the name of the people of the Philippines. And number two, notifies the accused. So it states that the crime committed and its details. The information spells out the exact crime the accused is being charged with. For example, the theft, homicide, or estafa. It is also includes the important details such as the time, place, and manner in which the crime was allegedly committed. This ensures that the accused is not left guessing about what they are being accused of. So according to the Article 3, Section 14 of the 1987 Philippine Constitution, guarantees that an accused has the right to be informed of the nature of the cause of accusation against them. And number 3, ensures due process. It protects the accused's rights to know the charge. The Constitution guarantees that no person shall be deprived of life, liberty, or property without due process of law. Filing an information ensures that the accused is properly informed of the accusation, giving them a fair chance to defend themselves. It prevents secret charges. It makes sure that the trial is transparent and just. So last is formalizes the case. It is signed and filed by the prosecutor. An information is not just any written complaint. It must be prepared, signed, and filed by a public prosecutor. This adds credibility and legality because it shows that the case has undergone preliminary investigation and there is enough basis or the probable cause to proceed. It makes the case official in the eyes of the court, transforming it from a simple complaint into a valid criminal case. So according to the Rule 112 of the Rules of Court, requires prosecutors to conduct a preliminary investigation to determine probable cause before filing an information in court. So now let's discuss the elements of an information. So the elements of information, as you can see, there is a title of the case. That example, People of the Philippines versus Juan de la Cruz. Another thing is accusation clause. It is what the accused is charged with. And another thing is date and place, when and where the crime happened. And another thing is law violated. It cites the legal provisions. And last is the signature of the prosecutor. It makes the charge officials. So I give you an example. For example, of an information. For example is theft. People of the Philippines versus Juan de la Cruz. The undersigned prosecutor accuses Juan de la Cruz of the crime of theft committed as follows. That on August 2025 in the Davao City, the accused willfully and unlawfully took one cell phone worth 10,000 pesos belonging to Pedro Reyes without consent and with intent to gain in violation of Article 308 of the Revised Penal Code. And filed this first day of September 2025 or signature of the public prosecutor. So in conclusion, an information is basically the starting point of a criminal case in court. It is the prosecutor's way of formally saying this person is being charged with this crime and here are the details. It makes sure that accused knows exactly what they are facing, and it also makes the case official in the eyes of the law. What makes it important is that it balances things. On one hand, it allows the government to prosecute crimes. On the other, it protects the right of the accused by giving them an unfair chance to defend themselves. So, in the end, information shows us the legal writings are not just about technical words, they are about protecting people, ensuring fairness, and making sure justice is served in the right way.